What's up, everybody? Welcome back. I'm tired tonight. Tonight has felt like a very long day today. Post work, I had two back-to-back events I had to go to. Just got home, kids in bed now, and the bat signal was loud and bright coming on Twitter, Instagram, all over the place on the comments of the YouTube video from earlier today about the most recent jury question, I guess we'll call it. It was almost more of a comment than a question, and there is a lot to actually unpack about it. Um, it sounds incredibly worrisome for the plaintiffs, but maybe not when you actually think about it and what could happen. Um, if you remember when they originally asked for the chart from Christy Kirby, the expert on the dollars, I said it couldn't go back. It was hearsay. It was never going to go back. So they should ask to have her transcript or her testimony transcribed so they could read it back to the jury. They didn't ask for it at that point, but they finally get to it now. So let's talk about what the question was. We'll listen to the judge read it. Thank you, everybody that watched earlier and that's watching again now. Hit that like button again. Every time we do a video, we got to hit that like again. If you haven't subscribed, make sure you subscribe. But let's jump into it. Yeah, I also saw a lot of people had thoughts about how the jury wrote their notes, which we can talk about that as well. All right, let's get to it.
Well, got another note from the jury. It says, y'all, we have not been able to locate any of the calculations about future amounts. Witness Kirby was on Zoom and Whitney mentioned them today, and it was said that we'd have all this at deliberation. Well, if we do have it, we ain't found it in all these files. So without these witness figures, you'll be lucky if there's enough awarded to pay your gas to drive to court, or we'll be here till next Friday. Here's the...
So did you catch that? I'm going to repeat it here. They basically said, we've looked through everything and we cannot find the report with Kirby's numbers. So, as a bit of a threat to the plaintiff, we don't have that. We're not going to award enough money for you to get gas. So, did the plaintiffs screw this up? Did the plaintiffs' attorneys mess this up? Did they not provide something that they should have provided? The answer to that is a flat out no. No matter what you do, regardless of how you argue, in the state of Florida, those reports almost never come in, especially when they're objected to by the other side. They are hearsay. They are demonstrative aids. Usually you can put them up, show them to a jury. You can show them to a jury during the testimony. You can show them to a jury during closing arguments. When we talked about the jury before and we talked about closing arguments, I said that what I usually do with life care plans is I take out the chart and in the summary, and it'll say like, this is how much they're going to need for this treatment. This is how much they're going to need for pain and suffering. This is how much they're going to need. And I write it down and I tell them, this is not going back with you. So write these numbers down now. It doesn't mean you have to pick these numbers, but these are the numbers, the evidence presented by the plaintiff. These are the numbers they point to. And if the defense didn't present any evidence like they did in this case, really with the numbers, I'd say this is the only evidence in this case. So write these numbers down. Now, they did talk about it, but I don't know if he was strong enough in telling them to write it down. Regardless, the plaintiff's lawyers did nothing wrong because this report was never coming in. And they're going to talk about it more. I will say a lot of people had problems with the language, and that's fine. If they thought it was too sarcastic, not serious enough, using ain't, using some curse words, whatever it may be. I think throughout the entire time, there's been some levity in the courtroom by the lawyers, by the judge, even by some of the parties have laughed about it. I also wanted to say, like somebody said something about the lawyers before, Howard Hunter walked over to the plaintiff's table, shook everybody's hand, basically said, good game type of deal. I saw that on the cameras. I wanted to, talk about it because a lot of people have had a lot to say, me included, about things happening in this trial. But This is the lawyer's jobs. They're not trying to snake or screw anybody over. They're trying to, fight for their side. And sometimes it's ugly, and we can point out when it's ugly, but he's not a bad person or anything like that. So I wanted to say that. And I know some people dislike the tone. I understand that completely. Dorothy said, why didn't they explain it to them and to ask for a replay? Well, let's hear how it plays out. And, I agree that explanation is key, but a lot of times you don't want to put stuff in the jurors' heads or give them things that they don't actually ask for. That's really important because it's a lawyer's job to put stuff in evidence that should be there. But the reason a readback is appropriate is the testimony is evidence. In a 9-week trial, it's understandable if they need some evidence repeated to them.
The verdict form, or the verdict form, the note form, if you want to come up and examine it.
Okay.
I mean, you all have hired a private court reporter, and if you wish to pay for
Of Ms. Kirby overnight, and then can we get the transcription of Ms. Kirby overnight, and then read her testimony?
well, I mean, you all have hired a private court reporter, and if you wish to pay for a court reporter to do something, that's between you and the court reporter. That being said, what is actually...
Sorry, I wanted to say one other thing why it might not be so bad for the plaintiff. What else did the jury not say in that question? What they didn't say is, we're going to award you nothing. They said, we're going to barely award you enough for gas to get to the courthouse, or we're not going to award you enough money to pay for gas to get to the courthouse. So if I'm the plaintiff and I'm going home, if I can get this readback, kind of seems like I've already won. The big question is just how much, which is kind of what I've been thinking was going to happen the whole time. They're going to win. The question is how much. And I think every question the jury has asked and everything they've done throughout the case says they are going to win.
in evidence on this issue?
So testimony, I believe, and we moved, and I think we marked for identification, but I don't know that we moved in or could move in her report. I tried to get her report in. Usually the economist comes in, but I don't think I was allowed for that to go in.
Correct.
So the report's not in evidence?
I don't think so. Yes, we did move it.
Well, it is what it is at this point. So what are we saying?
Well, I think the thing to do is let them know that we'll try to get her testimony transcribed overnight and then bring it in tomorrow morning. Hopefully our court reporter can give us an official transcript to be able to read to them, and that'll give them the numbers. Unless somebody wants to agree to let them see the report, which is marked for ID.
I mean, obviously, if they agree to it, sure, you can let it in, but that ain't going to happen.
Try to get it in.
Well, what is the defense's position on what to do?
There could be a readback, Your Honor, of the testimony. I'm exceedingly, I haven't looked at that report lately. I'm exceedingly reluctant to agree to have a forensically created report put in evidence. There are several bases upon which we objected to it and upon which the court excluded it. And I'm reluctant to revisit that. I'm frankly kind of surprised with this jury, with the note taking that went on at the tenor of the note, because I would have thought that they jotted most of this down. But I'm very reluctant, I suppose, to say anything other than the jury has heard the evidence and is expected to recall that evidence and trust its collective wisdom, or to read back the testimony.
You want to do nothing or as little as possible right now if you're the defense, because the jury's having questions. It's not a runaway jury for the plaintiff. I see some people saying, am I the only one that thought it was negative for the plaintiff? Absolutely not. I don't think it said you won't be awarded. I said you're not going to be awarded. I think they said you're not going to be awarded enough to pay for gas, meaning you are going to be awarded, is how I read it. But again, we're reading between the lines. Doesn't really matter at this point. Point is, they want this information and they don't have it. That should scare you if you're the plaintiff, that they think you dropped the ball. They think you forgot to enter something into evidence. They think it should be there. They think you told them it should be there. And this is just an indication of sometimes things get lost in translation, because I would be shocked if these lawyers said this report is going back into evidence with you. I don't think they said that. I think if anything, they said it's not going back into evidence with you, and somebody misheard it, and they all talked about, oh, it's got to be here somewhere, and it wasn't. And maybe they were taking all these notes, but they didn't write down the numbers because they thought the report was coming back with them. That should be scary to the plaintiff.
The jury didn't actually ask for a readback.
We offer that as an option nonetheless to resolve their apparent dilemma.
And the judge, I think,
Sorry.
honestly, since the jury didn't ask for it, I think if the defense would have objected, the judge may have said, just like with the calculator, we're going to wait till they ask for it. If they don't ask for it, we shouldn't offer it. But the defense, very surprising to me, says we're okay with a readback.
Mr. Anderson is asking if we should offer a readback as a.
That's what I was suggesting.
Okay. So perhaps then, since both sides are okay with me offering a readback, is to tell them all the evidence you have all the exhibits that are in evidence. And if as it relates to witness Kirby, we can ask the court reporter to see if the court reporter is able to type up the testimony. Now, are we going to identify what part of the testimony, or is the entire testimony going to be read?
This judge is really smart. He's really smart. He was waiting. Then when the defense agreed, he put it on the record. Both sides agreed. Evangeline Light said, got spicy. They tried. Defense rejected. I'm learning thanks to you. Thank you, Evangeline. Yeah, it's a lot to be learned, and to understand how this process works and why stuff comes in, why it doesn't, what affects the verdict. It's all really important. Jenna, love the shirt. Thanks for so much time today. Yeah. And it's actually funny. I was going to jump to Rebecca here, who gifted 5 memberships. Thank you, Rebecca. She messaged me and said, hey, you didn't answer my question today about she's already had CRPS. She's always going to have it. How do they split that up? Why didn't they talk about that? And I did answer this actually, Rebecca, but I don't blame you because it was like a 2-hour stream. So you may have missed it. If there's something pre-existing and the plaintiff is arguing that it was exacerbated or they made it worse with this horrible hospital stay, it's up to the defense to prove how much worse it got, if it got worse at all. If the jury can't determine how much worse it got, then they have to award the entirety of the damages. And that's what the plaintiff argued in their closing. Rebecca also said that the evidence about the CMS Joint Commission screwed the hospital's case. Yeah, that's why you got to be really careful about what you open the door to in these kinds of trials, because they're really going to just run a truck through it. Kelly, thank you for gifting the membership. It's so crazy how, the generosity just kind of continues to snowball with the current members. Jen, almost as if they are willing to give something but don't really buy it. If they were on the plaintiff, why would they be so snarky to them? I think they've been snarky to everybody throughout the whole trial. I think the defense has felt the brunt of that, seeing how they want to disqualify 1 or 2 jurors already because of, kind of their, the vibes of their questions. But I think that they're leaning plaintiff. That's just my guess based on how things have gone so far. Tay MF. Would the judge not have admonished the juror if he found it so disrespectful or out of line? Judges don't like to admonish jurors. They're there doing their civic duty. They've been there 9 weeks. They're hunkering down and working hard now. If jurors are falling asleep and not paying attention, judges will admonish them. But if jurors are very invested in taking this seriously because they throw a joke or a curse word in the question, most judges are not going to have a problem with that. Rebecca gifted 10 more memberships. It's awesome, Rebecca. Thank you. Netwoman, Peter, on behalf of the CRPS warriors in here, thank you so much for covering this case and breaking it down. It is especially this week. Yesterday was Color the World Orange Day to raise awareness for CRPS. How cool is that? That's awesome. And the super chat came in orange. How perfect. And Netwoman goes above and beyond here with 50 new members joining the fold. That's wild. Thank you, Netwoman.
If they
I do not believe was longer than 30 minutes max. I believe we were in and out. On
So
the
they go
brief-
through and they basically
on Zoom.
discuss, and
recorded.
at the end of the day, it's probably harder to
Well-
cut it up than it is to just play the whole thing. So they decide they're going to transcribe the whole thing.
My recollection of the case law on readback is as follows, that if the jury's asking for it, then obviously we can do it. And certainly that's not a problem. Obviously, are we opening the door for them to start asking for readbacks on
Everything.
everything?
And the only way this doesn't happen is if it gets so laborious, it's too hard, it's too expensive, they can't pay for this, can't pay for that. But usually, if the jury wants to read back testimony of a witness that you think is good for you, you're willing to pay for that testimony to be transcribed. So usually there's not a major issue there for either side wanting to pay for it if they think it's good for them.
Which of course, it takes a lot of time. And, I can tell them, I don't know if we're going to be able to get it for you overnight or not, but I'll say it's going to take some indeterminate amount of time to get it back. But unless the jury's request is specific, I don't want to do anything other than read the entirety of the testimony. Unless the parties jointly agree to some narrower scope.
That's what they
I
decided.
find it to
We'll go with what I had suggested. I mean, they said they wanted to go until 6:15, so this is probably a good time to stop anyway. I'll still have them come at 8:15 if they are able to do that.
And that's the plan. They're going to
I'll
come
give
back
them
tomorrow
the
morning,
option.
8:15.
25 minutes and 10 minutes of it, or, but
And
I'm open to anything.
I, I just don't,
Fish to fry, then who's wearing the right wig?
okay.
Talk about wearing
Never knows
wigs,
unequal.
dressing
That's what we're
somebody
gonna- let's
up.
Go ahead and bring.
Who's
and
gonna
have
come in
them
and
seal
read
up
it?
their-
Hunter says, I'll read it. They end up saying they're going to split it. Part of them's going to read part of it. The other side's going to read the other. So there's no issue with inflection or things like that.
Witness Kirby was on all we have done. Thank you. And then the other one says as follows, y'all, we have not been able to locate any of the calculations about future amounts. Witness Kirby was on Zoom and Whitney mentioned them today. And it was said that we'd have all this at deliberation. Well, if we do have it, we ain't found it in all these files. So without these witness figures, you'll be lucky if there's enough awarded to pay your gas to drive to court, or we'll be here till next Friday.
You'll be lucky if there's enough awarded. So I guess it could be if anything's awarded, but it sounds like they're going to award something, but will it be enough for gas money?
So did I misread that? No. Kind of?
So a juror says kind of, which is really scary for everybody. But you see, even the clients whose, life is on the line here, basically, or, their life was damaged by what happened to them. Even they're smirking a little bit. He says kind of, he's like, okay, hold on. I know we're joking around, but this is serious. Did I read it correctly? And she's like, yes, you did.
Well, I mean, this is serious. I mean, if I didn't read it properly, let me know. Okay. Let me say a couple things. One, you have all the evidence in this case. And so you're going to have access to everything that's there. And since we're going to be closing down for the evening, I am going to ask the clerk's office to go in and grab the evidence so we can put that in a lock room tonight. Your rooms can also be secured, but the clerk has its procedures and we need to do that. So if the clerk can go ahead and do that right now. Now, with respect to the specific request, in discussions with the attorneys, there's a possibility that we can have what's called a read back of the testimony of this witness or some portion of the testimony. Getting a read back, though, does take time. It's not any sort of instantaneous thing. We're going to see overnight if we can get that transcribed in a hurry. Can't promise, and I don't want to promise. So that could be an option for the jury. And if ultimately that is something that the jury is going to want, we can, if we're able to get that, we can give, if you give us a specific, what you're specifically looking for, then we can try to read back that portion or portions that the jury designates. So perhaps that is the way to address this specific issue. That being said,
Again,
I have
very
now been handed.
Clever and smart way to explain it to them. So they're not going to come back and just ask to reread the entire trial because nobody wants to do that. And at a certain point, you got to call it and you can't read back everything. Chris K, yes, this could happen in a criminal case as well. If it's necessary, if it's important, if it's just one witness and timely and one side's willing to pay for it. Keeley, how likely is it to have the transcript by 8 a.m.? Very likely. You want to know why? Money talks. And we pay for these transcripts. And guess what? When you want it rushed or overnight, you pay extra, and that's their job. And they're usually willing to do it if you're paying extra, especially because they hired a court reporting company for their own side for this entire trial. So they're probably on pretty good terms because they're making a lot of money off of this case as well. So I think it's very likely to be there by 8 a.m. Ask Tracy, RNJD. That's cool. Thank you for gifting a membership. And Bobby C. Thank you as well for gifting 5 memberships.
Did a sealed envelope with all of the juror numbers. I am handing it to the clerk who's no longer here. So we'll wait till the clerk comes back and I'll have her seal this up. Let's talk about tomorrow. First, since you're going to be breaking for the evening, you cannot have any further discussions about this case amongst yourselves, even when you're going to your car. Okay.
There's been talk in the Adelson case that maybe there was a juror group chat, which is a problem. We'll talk about that later. I don't have the capacity to do it tonight.
So you are finished for the evening. You can talk about other things like how wonderful Florida football is and how we're doing so well, but you cannot talk about
That'll be a short conversation.
the case. You cannot discuss the case. Do we all understand that? My instructions about not receiving any information, not seeing any media accounts continues to apply. Do you understand that? And also the whole idea of alternates no longer exists in our world. So we've got no safety net. Okay. So it's vitally important that you avoid all sorts of media or any sort of item that could possibly be an issue in this case. So do we all understand that?
And a lot of you said, why didn't they hold an alternate back? Their decision. I probably would have asked the judge to do it. We don't want to inconvenience people for no reason, but I would have said at least hold one back just in case, God forbid, something happens. But I think if one of them got sick, they might just take the day off for deliberating and come back the next day or something like that. Try to work it out to not cause a mistrial after all of this.
Now, tomorrow, I recall that we have to finish earlier. Is it 3 o'clock that we have to?
So I don't have to be in Northport until like 5, I think.
So we can go to about 4? Okay, so we will. So we plan on going to 4 if the jury wishes to go till 4 tomorrow. Okay. I have a
Unless
clerk
they
back,
get their
so
verdict
now
sooner.
let's have
Based on how they're moving, they can get Christy Kirby in at 8:15. It's possible they have a verdict tomorrow.
the clerk seal those numbers. And I just want to confirm with the members of the jury, each one of you saw that the verdict form was placed into that envelope. Is that correct? Okay. Let's talk about what time we're going to start. I want to try.
Before we get to what time they're going to start, which I believe is 8:15, let's get some more questions in. Dorothy, how would a juror know to ask that? It has to come from them. It's a great question, and they almost never ask for a readback, but you'd be surprised. Jurors start to get the feeling that they are kind of the bosses and the big shots at this point in the process because of how protected they are, how valued they are, how everybody's thanking them and empowering them, that you'd be surprised what they would ask for. And I've had multiple trials where they have asked if they could hear the testimony of somebody again. And basically, when they ask something general like that, can we read it? Can we hear it? Can we see it? We know it's being filmed. Sometimes they'll ask like that. Or it's like Zoom. Did anybody record it? Sometimes they'll ask like that. And that's how basically you take that as an asking for a readback because that's the most appropriate way to do it. I'm interested, though, if in the future they'll allow them to play back like the Law and Crime stream or, you know, whatever it may be. I'm interested to see if that becomes a thing. Danielle F., thanks for the coverage. Caught your trial info on replay a week ago, binged yours and Rob's recaps, and watched with Recovery Addict live today. Appreciate it being explained and happy to finally see you're live on it. Yes, happy you are here, Danielle. And if you guys are a new subscriber from the Take Care of Maya case, let me know in the chat. I love to hear when new people join the channel and join the community from a specific trial. So subscribe if you haven't already and hit that like button if you haven't already. Beautiful, messy ball. Are juror questions written by the foreperson? Usually, yes, but not necessarily always, but usually yes. And most of the time, that's how judges want it. Mom of 2 + 2. I transcribe tons at my law office. It won't take long at all. Yeah, 30 minutes. Come on. They can do that easily. They're champs. KO, thank you so much for gifting out a membership. Yes, Dorothy. John sent me something on this today. Becky Hill affidavit is out and denies all. Not surprising. A little surprising that she spoke, you know, with her Fifth Amendment right. Not surprising that she's denying it. So we will eventually check that out. Maybe tomorrow, if the verdict doesn't come out, we'll talk about Becky Hill or we'll talk about the Adelson jury stuff. No shortage of content at this time. Kaya, if the jury's frustrated with the chart not being in evidence, is it good that during the readback, they'll probably hear the lawyer mentioning that the chart won't be allowed during deliberations? Hopefully they did mention that. I can't remember specifically if they remember that, but hopefully they do mention that in there, and hopefully they're taking notes and they write down all the numbers so they know what Christy Kirby testified to. I got to know, can this up health costs? Storms affect homeowners. Honestly, it feels like everything affects insurance and everything affects health costs, and everything is going up. They do all this stuff that say it's going to drop the cost of insurance, and it never actually does. Insurance companies continue to make billions of dollars on the health side, on the car side, on the homeowner side, that I don't think anything's ever going to bring them down, and they're going to use any excuse they can to raise them up. I may be a little jaded, but that's my opinion on the facts here. Rebecca, thank you for thank yous, but I do it for the channel and the membership to get y'all started. This is the best channel, and it is really cool when new members get gifted and they come to the Members Only Live. We're doing it this Friday, and it's a lot of fun. We're going to talk about Discord and other benefits for the members that are kind of new and fun things that we do together. So yeah, it's cool. It's cool. And thank you, Rashenda, for adding a few more new members.
Try to give the jury as much time as possible, but I also recognize that you have families and obligations in the morning. So let me throw out, could we start at 8:15, or is that too early for you all? No,
I dropped my number off at, so the earliest I can.
you don't need to tell us where you drop it off.
I can be here probably a little bit after 8:10.
Okay. Okay, well, so why don't you all try to be in the parking lot by 8:10 in the morning? I'm going to ask the lawyers to be here at 8:15 because by the time you come in, we're not going to have a lot of things to do outside your presence. So we're not going to have those, be here at 9 o'clock and we start at 9:30. It's not going to be like that. But this is also very critical. When you come tomorrow and you're, riding with the sheriff and you are going in the back room, you cannot start deliberating. You can't start talking. We will bring you out. We're going to give you back the verdict form, and then might have some more information about the readback issue. Okay, so put a pause. No discussion about this case. Okay. Anything else I need to instruct the jury before we let them go for the evening?
No, we still got it.
No, that's plenty.
Okay. Thank you for your service tonight. We will see you tomorrow if you can be at 8:10, and then we'll start as soon as you all come on over.
All rise. Your next tape.
All right. So that is the end of the jury question. I'm going to hit a couple more questions here. If you do take off, hit that like button before you leave, please. Buck Sherry Lover, any opinion on amount of awards? So here's what I'll say. I don't know what number they're going to pick, but I want to say if it is, gosh, I don't even know. I was going to say 50 million, maybe 75 million. I put the over around maybe 75 million. If it's over 75 million, I think the plaintiffs will be happy. If it's under 75 million, I think they won't. Maybe when we talk about what actually for the plaintiffs, I think 100 million. I think if it's over 100 million, they'll be happy. If it's under 100 million, maybe not. I mean, but how mad can you be at a $90 million verdict? For the defense, I think maybe like 15, 20 million they'd be okay with. If it's under 15, 20 million, I think they'll be happy. If it's over, they'll probably won't be happy. But I think everybody's thinking big numbers in this case. I really do. Robin, why can't the judge tell them it's not in evidence? It's a great question. Because the judge cannot instruct the jury on what the lawyers did. He can't instruct the jury at this point that it didn't come in because it was hearsay and it was inadmissible. He can't say it didn't come in because the lawyers forgot. He can't fix any problems. The jury's got to rely on their own recollection, on their own memory. And at that point, or at this point, that's what you're doing. Hopefully it comes out in the testimony so they can get the answer. Netwoman said, Peter went up 1,000 subscribers since yesterday. Is that true? I don't even know how to see that number. That's wild. It feels like it, that's for sure. Mostly thanks to you, Netwoman. John O'Rourke, not new, but not totally in 100% agreement with Peter. That's great. Let's hear it. I know that is welcomed. And additional polite comments are what makes this channel better. Oh, I thought you were gonna tell me where we disagreed. But I know we've disagreed a couple times on this case. And Rebecca, same thing. We've disagreed a couple times. And some of the members and subscribers that are always in here, I enjoy disagreement. And honestly, I've said I think it's tough, the med mal claim, but I really believe the generally bad guy rule is applying to the hospital at this point, and it's stacking up. And I think the jury's going to hammer them with a big number. I don't know if it's going to be astronomical, but I think it's going to be a big number. Could be wrong. Could be wrong. Maybe it's going to be $250,000 like the defense asked for. Nonsense. Sorry asking again, but why can't they replay the Zoom? Seems easiest and safest. I believe the court said that they didn't record it and they don't have that capability to record it. But a readback is the most normal and common way. Again, we're dealing in the Stone Ages. Law is always years behind, but I'm trying to push to allow it to play it back so they can see the inflection. So we don't have to worry about, you saw them, oh, should we dress up? Should we wear wigs as jokes? But he was serious when he said, I don't want somebody to say she should get $238 million. They don't want her to do that, or say $238 million. They don't want it to be read in a way that's going to influence the jury. So why not just play it back exactly how she testified? And we should have that capability through streams, I would think. Janet, did you ever expect your channel to grow like this? Absolutely not. There's 5,000 people watching right now. I didn't think I would have 5,000 people subscribe to the channel, if I'm being honest. I didn't know anything about YouTube, really. I didn't know how it worked, how you could grow it or anything like that. But it's awesome. It's really awesome. Desi, welcome to the crew. And Sid, part of a new wave of members. Rebecca, don't forget the Fantasy League. Go Cowboys. Yes, Friday we're going to give a Fantasy League update. Azam, 286K to 287 in subs in less than 24 hours. Oh, maybe that's what Netwoman meant with subs. 300K subs sooner than you think, Peter. Thank you for your breakdown. That would be wild. I mean, if we could get it by the end of the year, that would be crazy, and I'd be so excited about that. But if it comes sooner, even crazier. Jen Goods, do you think the family would be okay with any amount as long as it's in their favor? From what I understand, they mostly wanted them exposed. Potentially, I think they'll be okay if they get to go to the punitives phase, right? If it's like $10 million, but they get to go to the punitives phase and the jury punishes them with another $25 million in punitives. I think it's not the number they may expect with all these huge numbers getting thrown out, but I think they'd be happy with $35 million in punishing the hospital and exposing them. I do think there was probably a lot of that in this. Tay Marie, fixed name. I'm embarrassed. Tay Marie, you'd be surprised what I see, the kinds of names I see on here. If this verdict is awarded to the plaintiff, will JHatch IJ open more lawsuits for healthcare? I don't think so. I mean, this case is so unique and so bad in so many different ways. There already are a lot of lawsuits in healthcare, some warranted, some not. But I don't know. I don't think this is going to change anything, honestly. Ryan Chappell. I think it'll change things on how people look at CRPS, and I think it'll change things on how like DCF and that type of stuff. But I don't think it's going to change things as far as the IJ or what happened with the Heart Institute or things like that. That was already bad. They're already paying tons of money for all of that. Welcome, Ryan. Ashley. Peter, problem with replaying the video is zooming in on other people's reactions. They'd have to just play the audio. Well, yeah, and that would have been cool if they could have just recorded the Zoom and we just saw Christy Kirby. But that is a very good point. TJ Truth, can you do a deep dive on the funding of JH and expose the Rockefeller influence on petroleum byproduct medicines and the AMA? Oof, that is over my head. I don't know anything about that. I have no clue. Welcome, Tiffany and Cali Girl. Lynn Alex, did the jury get to hear how much the hospital makes in profits? I believe that's going to be part of the punitive damages phase. I haven't seen what discovery they did for punitive damages or anything like that yet, so I don't really know what's going to come out there. Katie, the jurors are allowed to take notes or have a way to keep track of specifics of the trial. Yes, they are allowed and encouraged to take notes, and we've been told by all the lawyers that they've taken a lot of notes in this trial. Katie Sarfati, welcome. I probably butchered that last name. I apologize. John, gifting a disagreement and 5 new members. Hopefully at least 3 of the 5 agree with me and not you. Rebecca, it's because you are fair. Peter, you deserve all of it. Thank you so much. I really, really appreciate that so much. All right. I am tired. So I've got to call it a night. I appreciate everybody that joined. Please hit that subscribe button if you haven't already. We're pushing towards 300,000 subscribers, and hit that like button before you leave. Maybe I'll see you tomorrow if there's a verdict. I'm sure I'll see you tomorrow on Murdoch or Adelson or something else. Let me know in the chat what you want to hear, what you care more about, the Miss Becky stuff on Murdoch or the jury potential misconduct on Adelson. I'm sure we'll be hanging out and talking tomorrow, but either way, I got to call it for tonight. I am tired. I'm even a little hungry. Kathy's going to join us on the way out as well as a new member. Thank you guys so much. Until next time, I am out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed this episode, please hit the thumbs up and share with your friends who might be interested here on YouTube. And of course, don't forget to subscribe to our channel. You can also follow us on all social media, Twitter, Facebook, TikTok, at Lawyer You Know. But on Instagram, we are still at Tragos Law. So look us up on there. And don't forget to listen to the Lawyer You Know podcast, available on all major podcast platforms. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us lawyeryouKnow@gmail.com. Of course, all of these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.